Well, thank you everybody for joining, members of the gallery, as well as individuals from various political parties and cabinet office. I'm going to start. My name, first off, I'm Randy Hillier, MPP for Lanark, Frontenac, and Kingston, and I'm joined today with Asher Honickman from the legal firm of Matthews Abogado. And we'll start off by I've launched a constitutional challenge to Ontario's Election Financing Act. And I'll have a few remarks and then we'll open it up for questions. Of course, if the questions are more of a legal nature, Asher's here to provide in-depth clarification on the specifics of the legal challenge. To most people, our democratic institutions appear inert and static. However, the changes are ever constant, albeit incremental and subtle. Anyone elected to the Ontario legislature in 1867, were they reincarnated today and able to observe this institution, would find it unrecognizable and possibly question a member's ability to properly represent their constituents. Our Legislative Assembly has devolved from a design premised upon individual members being elected by their constituency with the responsibility of acting on and representing those constituents in the development of public policy, the law, and matters of taxation, to one where members are more commonly view themselves first and foremost as representatives of a political party's brand, and their role being to represent the party's interest to their constituents. Sir John A. Macdonald once said, "Parliament is a grand inquest with the right to inquire into anything and everything." This right has been gradually diminished and at times circumvented by the party whip to what best serves the party's electoral success. Regressive policies and legislation over the years have been established by successive political parties to entrench this authority in our institution, greatly restricting and diminishing public access and participation. We see this every day. Members are provided their talking points on every conceivable policy or subject, and they must be delivered without deviation. Members are provided the questions they ask members of the cabinet to drive the party narrative and the brand. Members must often get party approval to speak with the media or to table a petition on behalf of their constituents. Only designated members are permitted to speak in committee hearings and are directed not to use their judgment or ability to examine and inquire independently of the party directive. And of course, they must vote as the party directs them. Failure to abide by these constraints results in a diminished role to engage in debate, questions, committees, member statements, etc. In the end of Macdonald's Grand Inquisition, when members are directed to it, though, failure to abide by any of these have that diminished role to engage. In the end of Macdonald's Grand Inquisition, when members are directed to applaud, ovate, and tweet the party message at the expense of their ability to represent those who have elected them. My challenge, while radical to some, if successful, would provide members with a choice and options should they find it necessary to stray beyond the status quo and the de facto authority of the party. It would give independent-minded, conscientious representatives the ability to compete with the party brands on a level playing field. It would end the discriminatory policies that make it nearly impossible to be elected as an independent member who desires to represent his or her constituency rather than to represent a party brand. Just as members from 1867 might question the value of this institution today, a great many people today do question its value. We see complacency and apathy within the electorate. We see diminishing voter turnout and a lack of civic engagement. I'm confident that should this challenge be successful, it would be a significant milestone contribution to the defense of and advancement of our form of self-governance. I'd like to thank everyone who has provided ongoing support for these efforts. More in-depth material is on this Charter Challenge are available on my website, right2rep.ca. Thank you very much. Be happy to take any questions.
Randy or Asher, what do you think your chances are? I know courts sometimes tend not to like to weigh in on political matters. What do you think your shot is?
Well, I think the courts have actually made it clear that these sorts of laws would contravene Section 3 of the Charter, which provides the right to vote. I think where the battleground is really going to happen is at Section 1, whether it's a reasonable limit. And excuse me, all I'll say on that score is that I think we have a really good chance, because I don't really see any real pressing and substantial need for these kinds of laws that hamper the ability of independents to run in a fair process. Nobody's talking about scrapping political parties. Nobody's suggesting that independents will be the majority of legislators. All we're saying is that independents should have at least some voice in the process.
Randy, one of the things that people who defend the status quo say is you could have a situation where people who are saying they're independent, I'm going to run as an independent candidate down the road, and they raise money, but it's a fraudulent kind of fundraising scheme. I mean, how do you circle that square?
Well, I guess I could say any law can be abused, Rob. That does not mean that the law should institutionalize a discriminatory function because someone may abuse it. And I would go further and say there probably is not a law that is on the books that hasn't been abused, and sometimes with quite regularity.
Do you think this is something, this law as written, is something that political parties don't want to see changed?
I have no doubt that political parties do not want to see this changed. And I can give my own experience on that. As a member of the standing committee that sat through the summer of 2016 examining changes to the Election Financing Act and having representation by the chief electoral officer, some very high profile and knowledgeable individuals from the private sector and the public sector, as well as the integrity commissioner. There was clearly a strong recognition from outside the political process that reforms needed to happen, and a significant reticence by political parties who were represented on that committee to allow.
Is this because they have kind of a monopoly or a not a duopoly, a triopoly, whatever? They have a closed kind of
They have it's a closed marketplace for political representatives. If you do not, and maybe I'll just state this just because everyone is aghast when I tell them this, that the law actually prohibits me and any other independent member from raising funds for my re-election. Now, every member in the House who is a member of a recognized political party are raising funds today and every day for 4 years up until the election. I've done it in the past as a member of the Progressive Conservative Party. That is no longer an option. I'm prohibited from raising funds. And there's another number of other aspects, but that's really is the key to it. And people are astonished that our laws can be so discriminatory to actually preclude independent members from having and engaging on a level playing field. So parties, this is, there's a reason why there's only been one independent member elected in Ontario in the last 80 years. And it's not just because there's no interest. That was Peter North in 1995. I believe 1990. Yeah. Yeah. One individual. And that's, it is just about an impossibility with the laws as they're presently constructed.
Randy, I haven't scanned through the affidavit yet from the website, but I mean, is there a specific change to the law that you're looking for, or are you just asking the courts to strike down what you say is discriminatory, or what's the end game you're hoping to see?
Well, maybe I'll just preface a response here, and then I'll turn it over to Asher. Everything, we've looked at that. We've looked at it in detail. And everything hinges in the Election Financing Act on the establishment of riding associations, electoral district associations. That's the mechanism that is used to raise funds. See, the mechanism that members use to expend funds throughout their mandate, to continue to improve their representation of their constituents. Of course, independent members are not allowed to have a constituency association. So that would be one mechanism, is to permit independent members to have a constituency association. And Asher will give some more details on that. But failing that, then it would be potentially to scrap the whole law.
Part of the problem is the default assumption in any charter challenge is that an unconstitutional law is struck down. It's very rare that the court will read into a law words that the legislature didn't choose to include. And in the case of the Election Finances Act, as Randy was saying, the concept of riding associations, constituency associations, is so interwoven into the act that you can't really just read in a more inclusive definition that would allow independents to form their own constituency associations without completely rewriting the statute. I don't think a court's going to want to do that. I think what's more likely is that a court would strike down the legislation but allow for what's called a suspended declaration of invalidity, where the government could have some time to go back and rewrite the law, and the law would continue to operate during that time. Alternatively, what we're seeking is we're targeting specific sections that could be surgically removed from the act. So we're saying that this whole thing doesn't work, but in the alternative, if you find that some of it does work, these specific provisions definitely don't work, and they can be excised without much fuss. So an example of that would be the what happens to surpluses at the end of an election. Right now, it says in black and white, if you are a member of a party, your surplus goes back to your constituency association. If you're an independent member, your surplus goes to the chief electoral officer, never to be seen again. Parliament has dealt with this already. Last year, they changed the federal law so that independent surpluses can be held in trust for them. So Jody Wilson-Raybould will be able to get any surplus she had back. At the provincial level, we haven't even made that change yet. So that's an example of a specific provision of the Act that we could ask the court to strike down that would still allow the rest of the Act to stand. But obviously, that's one of about 3 or 4 major problems. So we're obviously not confining the challenge just to that issue.
I should add one more thing. None of this is new. The Royal Commission on Electoral Reform, the Lortie Commission back in 1991, studied this in great detail and provided their recommendations, such as surpluses, the creation of constituency associations. There was a lot of work done, and that was followed up with a significant number of recommendations by Elections Canada. In early 2000, I believe, that time frame. And then there was also the full standing committee in the House of Commons, the Standing Committee on Parliamentary Reform, also has examined that. And the recommendations are there. But the political parties have not had the motivation or the desire to fully implement them.
If I could ask, I mean, obviously, this will all get hashed out in court, but it is possible for the government to argue that political parties actually form a important and normal part of a parliamentary system, and that it is reasonable for public policy to favor them. So you mentioned the Section 1 test earlier, but I'm like, why is this so discriminatory that you think it has to be struck down?
Well, because even if you didn't have these discriminatory provisions, there are still other provisions in the Election Finances Act that we're not even challenging that provide for parties to raise certain amounts of money. So, for example, the annual limit that applies to constituency associations to individual candidates, there's another annual limit for parties. So parties would still enjoy an advantage even if we were successful on everything. And then they would also enjoy, I think, a de facto advantage, because most people who are voting do typically want to vote for a party. We have a constituency-based democracy, but many people do think of many people do think of individual, or rather of parties rather than their individual MP or MPP. So my response to that is that nothing we are suggesting would upset the fundamental balance that parties would make up, the vast majority of MPs or MPPs in this case. All we're saying is give independents at least a chance to bring their independent voices into the legislature.
I had asked the House Leader, Paul Calandra, if there was a way back for you into the party, and he said that it was up to caucus, that if someone brought it to the caucus floor, that would be a discussion that they would have. Is that something you'd like to see, or maybe ask?
That's their determination. I would say to you, it was a decision by Doug Ford. It'll probably be Doug Ford's decision afterwards. Thank you very much. If there's any questions later on, like I said, for those who were joined us late, all the documentation is up on the righttorep.ca website, and I'll be happy to provide any further clarification down the road.